not on yet. Welcome to Planet Green Trees. Welcome, everybody. You're on, not yet. Have we launched?
We have launched.
All right, we are on and going. This is officially episode number 156. We're calling it People versus Jones, Immunity Decisions. We'll talk a little bit more about that shortly. But it's an exciting night and got a very exciting show. Today, of course, is July 11, 2013. The call number is 1-347-326-9626. I'm your host, Michael Komorn. Beside me to help you bring the most up-to-date, informative, and entertaining medical cannabis and cannabis reform information, Chad from the Birmingham Compassion Club.
Good evening. It's nice to be here.
Jamie Lowell from the Third Coast Compassion Center and Lowell and Associates.
Yeah, that's right. Hello.
And, of course, Rick Thompson, the editor-in-chief of the Compassion Chronicles and recently appearing in the USA Today International newspaper. Oh, hold on. Try it again. Wait, go ahead. Wait.
All right. Here we go. I'm so good I can continue to talk about me
all day long. There
we
go.
Yeah, we're going to have some problems. Let me warn everybody, we're going to have some problems with the mute button, so I don't want any inappropriate unmuted comments.
I'm often muted appropriately.
That's right. So as many of you know, because of the frequent listeners and return listeners, every week Planet Green is proud to bring you the top cannabis lawyers in the state to give their comments, reflections, take questions from the listeners on various issues and topics that challenge the medical cannabis community. As always, we'll be discussing current court cases and events and encourage our listeners to call in and join in the conversation. Of course, the theme of tonight's show, the name of the show is People versus Jones, and we're calling it the Immunity Decisions. And as we begin to tease the show a little bit, I'm going to be talking a little bit about the case and what it means. But when I talk about immunity decisions, we're talking about really for the first time, not really the first, but the second time where the court has begun to address Section 4. But booked by our outstanding producer and very, very timely, the lawyers that we speak of the top in the state, they're going to be calling in to give their comments and reflection, will be, in fact, the lawyer for Mrs. Jones. Daniel Groh, good friend of the community and a warrior, was the attorney for Cynthia Jones, in which the Court of Appeals reversed a Berrien Circuit Court Judge finding held that the MA's Section 4 immunity fact-finding is a question for the trial court to decide as opposed to the jury. Also joining us will be others familiar with the case. I understand that Ms. Jones is...
Her significant other, Sail Ali, will be calling in.
Fantastic.
Well, very familiar with the case. Will be chiming in.
Okay. And, again, couldn't be more timely. And, of course, you'll be hearing from our good friend Barb Agro and son Nick Agro, who many of you may recall in what we would describe as the end of the Renaissance era. Their homes were raided, and they were charged in court. One of the tragedies of it all was that husband, Father Sal Agro, died of a heart attack about 10 days afterwards. And many believe and are convinced that this horror of the raid, of dealing with the government barrage in those moments, shortened his life. But they're going to be calling in, and I know that, fortunately, I think Nick's case was reinstated after being originally dismissed, and I know Barb's case, fortunately, was reversed on appeal, and I don't know if...
She has a court date coming up, and she'll be able to update us on all of that kind of stuff.
We'll hear more about that. And those of you that don't know the story behind this, it is really one of the most outrageous stories in the criminal justice history. Like, you would never think things like this take place, and maybe they only take place in Oakland County, but it is still one for the ages. The contributions for tonight's show come from our good friends and those in the studio who work tirelessly all week long for no pay. Rick Thompson of the Compassion Chronicles, Jamie Lowell, Third Coast Compassion Center, of course, Chad. Tonight's host for tonight's show, Komorn Law, 1-800-656-3557. The Michigan Medical Marijuana Association, michiganmedicalmarijuana.org. I want to thank all the moderators and administrators that work diligently to try to create a safe environment for the community to evolve the conversation about medical cannabis and cannabis reform. Shout out to our good friend Kevin Spittler from the formerly Med Joint Community Center in Oshtemo, Michigan, and also one of the directors of the Ohio Cannabis Reform Group. And, of course, our good friend, the marijuana rancher from the Cannabis Culture Center, also known as the Marijuana Ranch. Call for updates and different types of entertainment and tours of the Cultural Center, 313-422-5281. As we've outlined here, we've got a very exciting show. Dan Groh will be calling in. The attorney, Dan's a fantastic lawyer, and I presume he's going to be able to articulate much of what took place. And, of course, we've got Barb and Nick calling in. I'm going to rant in a minute. I ran for a minute. There's always a lot of things to talk about. I want to talk a little bit about the immunity case. But I also want to talk about something which kind of blends with this, and it just deals with the general perceptions of what has become our law enforcement community. And I don't want to tirade about the law enforcement in general, but I can't help but identify, and I want to make this point, that as you look at the history of the law enforcement community, we've heard this from our guests, members of the law enforcement community, commenting on this is what's wrong with the community, but it is no longer the police are protecting and serving. That just seems to have gone out. And what I'm saying is that the entire dress code on the way in which law enforcement is acting in these raids, and I heard today horror stories of clients of mine that expressed the, what it's like to have, for what you believe is lawful behavior, the government pound down your door and just treat your belongings and your possessions just in an animalistic way. And it's very disturbing. I mean, my comments afterwards that there's got to be, only a certain type of person would want to be part of that. I mean, there's something inherently odd with sifting through people's belongings. It's part of the thing. I mean, whatever your justification is, the idea that it's important to sift, and for some reason doing that to the extent of, people's underwear drawers, or, taking their sex toys, or whatever it is, whatever they're doing in there, and whatever the extent of it is, the idea that our government and the freedoms that we are afforded have come to this. And I mean, my clients today were discussing how the officers that came in, they have, wood floors, that the officers were wearing golf cleats, and we're laughing about it. It's my playground. It's my playground. You sit down there, and golf cleats tore up the house. They broke down a door. They broke down a door that the husband and wife had built together. It was like one of the, they went through the whole process of making it and putting it into play and getting it built, and it's like a symbol of their home, their relationship, and that had just been beat down. And they commented afterwards, wow, that was a really strong door. Was being the operative. But, and the other thing was, like, when my client, whose room was raided, he commented on, your belongings that you may have put away get torn apart, get thrown on the floor, and get disseminated as meaningless. And it may not be things that you want to look at. It may be things that you put away for some other time. But just that it's all torn apart, your life in the floor and done by some invaders. Just, I hear it, it's a terrible thing. And read a recent article discussing, and Jamie, I know we're going to talk about this in another episode, the Third Amendment principles of how this all plays into it. We know that the Fourth Amendment has been litigated, and Fourth Amendment right to be free from illegal searches and seizures by the government, and all if not most of the litigation that's come about has been driven by the war on drugs, that the courts would have never heard the number of cases that they have had to, both trial, Court of Appeals, Supreme Courts, and all the way up to the federal level. But they are inundated with the majority of their issues dealing with constitutional principles about the government getting into people's home, driven, facilitated, creating the work and the business for the court from the war on drugs and those issues. And it is just fed the animal, and the animal is grown into a monster. And the courts are inundated by these issues because of the war on drugs failures. It's like a place where it's all mopped up and some semblance is tried to put together, even though it's not. And the monster on the other side is a entity that is no longer a police force. It's no longer a police force as we've come to know, but instead it's developed into a military force. Dressed like military. Ask an officer in some of these raids what they wear when they go in on the raids. They will tell you military helmets. They've got AK-47s. They have bulletproof vests. They've got military gear. They're coming out of vans that are military. And the Third Amendment issue comes up, and we will be getting into this a little bit more, is that discussing how the military is not allowed to go into a person's home and take over, ever. And there's very little litigation. And it's a period of time, I mean, that not by the citizens' request, but by the evolution and growth of the animal, may be a discussion in the future. All right, I want to turn to the Court of Appeals case, and we're going to hear more of it from Dan Groh. We'll be calling it, 8:30? Yes. Okay. But specifically, and as we're calling the show immunity decisions. So we discussed the Michigan Medical Marijuana Act, and the context that we're going to talk about today, as far as this case, is that there's two levels of protection. And there's been much criticism that the levels of protection on Section 4, or what's the immunity, or in simple terms, when you have an encounter with law enforcement and you walk away, whatever it may be, if you're a caregiver or a patient, it means that after evaluation and scrutiny by the law enforcement agent who learns about your caregiver or patient status, it's a positive one because you have found yourself in compliance with the strict conformity of Section 4. And if someone is and finds themselves in that, they are excused from prosecution, arrest, or any penalty associated with the behavior because they are in compliance and they are exempt from the normal criminal penalties that would go along with that admitted behavior. Meaning, marijuana use is, according to the courts, illegal in Michigan. Always. Public Health Code prohibits it. But in these limited instances in Section 4, which we'll talk a little bit about, and you encounter law enforcement and you are engaging in this illegal behavior of the use of marijuana, but your behavior conforms to Section 4, it will be seen in a way that is immune from arrest, prosecution, or any penalty. And this is very, very distinct from Section 8. And I would say briefly that without question, the biggest criticism of the Act's implementation, the way the courts have interpreted it in the grand scheme, is that this part of the Act that I'm talking about, the immunity from arrest, the card is supposed to mean something, that the intent of the voters was to create a law that was broad and protected a number of different, not specifically enumerated within the Act behavior, but it was medical in nature, and that in doing so they would be protected from arrest and prosecution or any penalty. Meaning, when the Court of Appeals ruled in People versus Balsma that two patients could not grow in the same room, or said another way that a husband and wife couldn't grow in the same room, they could have said that they could. And the language in the Act could have led them to find those conclusions, but they didn't. And thus, the protections that an individual has in terms of how they're going to grow became more narrow. If a husband and wife are growing together and they're each patients with one room and it's still locked and closed, that would be a violation and subject those two individuals to arrest. So the criticism, of course, is the court did not have to do that. They could have seen the Act as being more broad and prophylactic and said, why would we ever want, do you think the voters intended for grandma and grandpa to get dragged into court because they're growing in the same room? I mean, and by doing so, are we not allowing law enforcement to look for the violations of these protections? But nonetheless, that's where we are, and that's the criticism. The other criticism regarding transfers, People versus McQueen. Can any caregiver transfer any patient? If you've got a card, can you get cannabis from any patient and be protected from arrest or not? And we know from McQueen that at least one of the Supreme Court justices said that's what the voters intended. That's what this Act says. That's what the case law thus far suggests, but the majority opinion said no, and only the patient of the two individuals involved in that transaction is the person that's protected from arrest, prosecution, or any penalty. The transferring medical cannabis to the cancer patient that's sick and dying, who, is not one of the directly connected to the caregiver's patients or the sick patient, that transaction is arrestable. Is there criticism warranted for that? Absolutely. And without question, all of these decisions could have gone either way, and they all could have been on the side of expanding the protections of Section 4. Instead, they didn't. In all the scenarios that I described, despite the fact that an arrest may result because of the behavior being outside of the exclusions enumerated in Section 4, you do have a Section 8 defense, which we talk about a lot. And the significance of the Jones case out of Berrien County is that it is one of the ones that really gets on point with some of the unknowns of how the act is being interpreted. For example, we know that a person may claim immunity and say that, you know what, my outdoor grow was absolutely 100% locked and enclosed, that nobody else could ever get in there. There's no way in the world anyone could get in there. And that no one else has access to it. I don't care what definition you use, how it is, but that place is locked and enclosed. And law enforcement raids anyways, for whatever reason. They say it has to have a roof. I'm not saying that this is a determined issue, but let's say that that's the issue. And I'm not talking about the 2013 amendments. I'm talking about the outdoor grow. But nevertheless, let's say but whatever it is, let's say it's the outdoor grow. Let's say that the officers say, for example, under the 2013 amendments, that from the neighbor's property the plants are visible. And they write that in the report, and they say that put in the search warrant. But the reality is that nowhere around the property is that true. And the neighbors are so far away, and the circumstances are such, but they say it, let's just say, or they think it, and they see it, or they believe they see it. And that's the basis for the violation of your outdoor grow. You are no longer immune from prosecution penalty because you've been arrested. Or you have at least, the police have asserted that you're not immune from arrest, and they've charged you with an offense, and the prosecutors affirmed that by issuing a complaint against you, alleging that you violated the public health code for manufacturing marijuana. So you go into court, and does that mean at this point in time, because the police have said that they believe in that moment, which is the impetus of the entire prosecution, because had you been in a locked and closed facility, you would have been immune from the arrest and prosecution that drags you to court. The question is that a dead issue at that time, or does the defendant have a right to argue that at any of the proceedings, and what is required, in fact, at those proceedings? I had an argument today in court that I'd have a Section 4 hearing, and that the cards are irrelevant at the preliminary exam, where the issue is whether a crime has been committed and whether or not there's probable cause to believe the defendant committed it. And I looked at the prosecutor and said, are you serious? How can you say it's not relevant and that I need a hearing? I'm here to assert immunity, that this prosecution should not take place because my client is in compliance with Section 4. How can you say that the card is not relevant or that I have to have a hearing? I'm presenting the card. The law is the law. And the presentation of the card should stand for something. And we argued about it in the court, of course, admitted the evidence and let me argue about it. But the point is that there's been very little written about the Section 4. But what begs the question, and is something that I've discussed and questioned a lot, and I don't know that this case is the end of the line, and I don't agree with this opinion, but the question that was posed here is, when there is a debate about whether or not the grow meets the definition of the amendments of what a outdoor grow may look like, or one officer testifies that from the vantage point that they were at that day, they could actually see the plants from the neighbor's property, when the neighbor gets in the stand and says absolutely impossible even. And there's a conflict there of fact, and the question becomes, who is going to be the individual, or who is going to be the body that is going to decide who's telling the truth? And what happened and who is going to be believable, and who's going to be the ultimate person that decides whether or not this dispute over compliance with Section 4, whether the total weight was 2.6 ounces instead of 2.5, whether that 13th plant is going to be considered a dead plant, a clone, and it's going to meet the definition of a plant or not, and whether it's going to be considered the 12th or 12 or under, which would be in compliance or considered a 13th plant. All of these things have been decided at various times up to date, in some instances all instances, I would say, by the courts. Courts make a ruling, no, counsel, that's not the way I read it. It would seem to me that a locked and closed facility should be, especially outdoors, so that no one can smell it. I had one judge tell me. I said that because the fact that you can smell it outside means that it's not locked and enclosed. I mean, it can, but that's a ruling that a judge may make. And the question then is, okay, I disagree with you. Is that it? Is it over? Do we have a right to present what I would argue are factual issues, factual determinations before the traditional trier of fact, the jury? In fact, a good argument could be made that the same theories used by the Michigan Supreme Court in coming to the conclusion and lowering the bar, lowering the threshold of getting to a jury to present a medical marijuana defense, especially in the remand in People versus Anderson, where the threshold of evaluation of the testimony by the court at the Section 8 hearing is not to judge the credibility of the witnesses, not to weigh evidence, but just to merely make a decision of whether as a matter of law, all three prongs, some prima facie evidence has been established as three prongs, meaning that's a low bar, and the justification for it is that they looked directly at the voter initiative, the Supreme Court did, and they found that the fourth paragraph dictates that if the voters pass this law, both registered and unregistered, since a caregiver shall have a defense to any charges involving marijuana, and the only way to facilitate the voters' will is to allow people and afford them the opportunity to have a trial and present a medical marijuana defense, which is what has happened. And again, the criticism is that this interpretation of righteousness and the voters' intent should have been for the Section 4 and not just for those that have been already arrested and have to hire a lawyer. But it would seem that the same logic could be drawn, the same principles outlined in the fourth paragraph of the initiative could be applied to the concept of who is it that will decide what is locked and enclosed? Who is it that will decide whether the weight offered at the hearing or preliminary exam is going to be evaluated in what way so that the judge is going to decide, or can the judge decide to dismiss? And then, if not, it's a question of fact for the jury. Well, what happened in this case is that there's a number of different issues that have been up on appeal. But at the end of the day, there had been a ruling by the trial court that had found that the questions of immunity would be one for the jury to decide. The trial court had decided that. Unfortunately, I argue, the Court of Appeals, in analyzing the lower court's decision, came to the conclusion that the trier of fact, the person that will decide the facts in a Section 4 hearing, will not be the jury. It will be the judge. It means that all the decisions, according to this case at this point, that will decide what's locked and enclosed will be the judge, and there will be no hearing on that issue before the jury. And the court gives a very, I think, a weak rationale, relying upon other situations where the courts are, in fact, determining questions of fact. The arguments go that questions of fact are determined by the jury. Who's telling the truth? Who's lying? What was the distance from here to there that the witness said? Was it light out? Was it dark out? Was it raining? Wasn't it raining? How fast was the car going? Was he drunk? Was he not drunk? Those ultimate questions of fact are always decided by the jury, and in assessing the facts as they come through the witness stand, they apply the law that the court gives to it in their deliberation. But the law is decided by the judge. The total determination of what is a lawful search is decided by the judge. Whether the individual consented to a search is for the judge, and these are not issues for the jury to decide. They're not matters of fact or questions of fact that require the evaluation of the human spirit as to whether they're telling the truth or not, or whether or not the credibility of the expert is to be believed, or whether the police are telling the truth or not. So, and this is the law. This is the way it goes. However, in limited instances in Michigan, there's situations where the Court of Appeals believes used and rationalized, such as entrapment cases. Meaning that when someone has a defense to entrapment where person was engaged in lawful behavior and the government agent in some way entices them to do behavior that they would have never done but for the enticement by the government, and there's no other behavior that's like that the government alleges is illegal, but for the one instance or two instances or instances instigated by the government and their enticement. That issue of whether or not an individual is going to be able to utilize that concept is going to be determined before a judge. But at that hearing, the Court of Appeals says the judge, at a hearing to determine whether or not the elements of entrapment have been established, the court does, in fact, evaluate the credibility of the witnesses. They do evaluate credibility of witnesses in other hearings as well. Issues of whether or not Walker hearings, where issues of fact come up in the evaluation of a witness that gets on the stand and may say, I'm the defendant, and I know they said that I waived my rights, and even though they don't have a signed Miranda form, and after they say I waived my rights, I began to tell them everything that I've ever done wrong, including the 4 crimes that I'm being charged with, and they detailed it, but it's not written down, but they say that I said it, and they wrote it down. And I'm getting on the stand and saying I never said that. It's a bunch of lies. The court's going to have to make a decision whether they're going to believe me, discounting the statement that was made, or whether Miranda warnings were made, versus the police officers are going to say just the opposite. So it does happen in that regard. And in doing so, these things ultimately are not allowed. I mean, technically not allowed. They come up sometimes strategically and sometimes by accident, and sometimes you want them to come up. But they would then thus be, if they're ruled upon by the court, the judge, and they're resolved, they are not issues for the jury. And it excludes you to a certain degree. Sometimes the strategy may be not to argue about an entrapment issue because the court would rule and make a determination that there's no entrapment here, I don't know what you're talking about in front of the jury. Whereas if you don't argue that, the jury may be absolutely appalled by it, and it may have more of an impact on the ultimate decision. But at the end of the day, the decision here in the analysis used and relied upon, I don't agree with. I mean, the way that the Act is written in the 2 sections, we've become used to seeing it in 2 different positions. But at the end of the day, there are really genuine, specific definitions that have not been determined by law. You know, the amendment to the what an outdoor grow should look like are 50 words that are very poorly written in a bad order and bad combination, and does not give a lot of insight. And I promise you there'll be a lot of litigation on that. But to have a court make determinations and not allow a jury or the peers and contemplate the the totality of the circumstance, I think may be a flawed ruling, and we're going to be interested to hear about what Dan Grove's intentions are of the client moving forward. What we are going to do in the meantime is we're going to take a quick break. I'm going to wrap it up, and as far as my rant, and we will hear more from our esteemed colleague, brother counsel, Dan Grove, shortly. But for right now, we are going to take a break, and we'll be right back. Listen, Planet Green Trees. The call-in number is 1347-326-9626.